Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney James Ra'anan walks us through the drama between Elon Musk and Twitter. So, let's tear it down. James Ra'anan, welcome back to the Contract Teardown Show. How are you today?
I'm good. Thank you for having me.
I am excited because we're getting into the drama. These contracts where there's like nerdness and drama at the same time is my favorite kind of Venn diagram. We are talking about this document, the agreement and plan of merger between Twitter and Elon Musk. What is this document? James, when are we going to see this kind of thing?
So you're absolutely right. This is contract theater in motion. This contract is a pretty much typical agreement for a public company acquisition and merger, and obviously this is the agreement that's been used between Elon Musk and Twitter.
And for you, coming to this kind of document, I'm assuming you're dealing with these kinds of things a lot. We've talked in the past about similar agreements, but what's your background, James? What brings you to a document like this?
So my background is being both in-house and in private practice over the last 20 years, both in Europe and the US and Israel. Mainly in mergers and acquisitions and commercial work. So it's rare that you come across, obviously, agreement of such value, but they are pretty common. And in many ways, this agreement has many standard clauses, which you see in other merger agreements. But it's interesting to see how they're playing out in real life in such a short space of time after the contract was entered into.
So before we dig into it, James, just to give a little bit of background, just the facts as they are right now. Today that we are talking is June 13th, 2022. I think we're about a month or so into the back and forth about this contract. Give us sort of a brief state of affairs. Where are we in terms of wrangling with this contract?
So if you kind of look at the chronology of things, so you had in early April, Elon Musk taking a position in Twitter, becoming their largest shareholder. Stock price goes up significantly. Very quickly after that, he begins bidding to buy all of Twitter. And then after some back and forth, enters into this agreement to pay $44 billion for Twitter. And fairly soon after that, things start to, you could say, unravel a little bit. And it's really speculation outside of my scope, but it could be because of the reduction in stock price of Tesla or whatever it is. But very quickly, you get into a situation where the contract is subject to different conditions to closing, one of which is antitrust approval, which there seems no reason why that shouldn't be forthcoming, and ultimately a stockholder approval. So once those items have been squared away, then there shouldn't be any reason to hold up this deal from going through. And so, as you alluded to, there's been some heated back and forth over the last couple of weeks, several weeks, where it looks as though one of the parties is looking to try and either renegotiate or maybe even exit this agreement.
Yeah, there was a moment in time, whatever their particular motivations, I mean, not just Musk's, but also Twitter's motivation to sell is an interesting thing and trying to figure out why are they doing this. But the point is, in a contract like this, you're picking a moment in time. You're saying you guys are coming in with whatever assumptions you have about what's true so that we can wrap this deal. But we have to pick a moment in time. So this is the moment in time. Whatever your assumptions are, let's nail those down and put them into this agreement so that we can do the very heavy lifting of moving this boat, turning this boat, and making this transaction happen. So there was a moment in time that they said, this is the day, these are the assumptions, let's go make this happen. And now we're at this point where did things change in a way that matters to the contract? And so we're going to dig into that by starting with section 6.4. 6.4 talks about access to information that the company here, Twitter, will reveal to Elon Musk and his people information that they'll afford to the representatives, officers, directors, employees, agents, etc. of parent reasonable access in a manner not disruptive in any material respect. Some of the details of the business. So there's got to be an exchange of information for this deal to happen. What do you think about Section 6.4 and what it's trying to do?
So just as I go down to Section 6.4, I think just part of the backdrop to this of why this is a relevant question is because in the back and forth between Musk and Twitter, he's asking for these information on the Twitter spam accounts and how they came to that number and how that's calculated. And you may have seen in the media that Musk is quoted, or they say that Musk waived due diligence. So what that really means is that he entered into this agreement pretty much based on the public filings of Twitter, and didn't do his own independent due diligence. And so the type of information that he is asking for at this point is more typical of the type of information that you would have asked for before you signed an agreement, typical information that you would ask for in a due diligence review. And so the contractual question is, does he have the right to receive that information? And there's an interesting back and forth. So what I think his lawyers are trying to hang their hat on is this provision, Section 6.4, where it specifically says that he has to furnish promptly to the representatives all information concerning the business, etc., as may reasonably be requested in writing, in each case for any reasonable business purpose related to the consummation of the transactions contemplated by this agreement. So the whole question really is, does the provision of information about these spam accounts, is that reasonably related to consummating the transactions under this agreement? Now, the lawyers for Twitter may say, that nothing to do with it, that's a phishing exercise, and if you would have wanted that information, you could have asked for that beforehand. But it's quite hard to take that position. And I think Musk's lawyers would probably argue that, no, we need this because we need to be able to persuade our bankers to put up the money, and everybody has to be comfortable that the spam count that you say is the spam count is the spam count, and they're enough to that, and that's why it's relevant. But it's not a no-brainer, but it looks as though for the time being, Twitter has chosen to provide this information. And it's an interesting piece of gamesmanship sometimes when you find yourself not exactly in the four corners of the contract. You'd come with what I would say is quite a little bit of gamesmanship to ask for something which is hard for Twitter not to give. Because if they don't give it, it looks as though they're hiding something. And obviously, as a public company, that has its own ramifications.
Right. And you made the point before that Twitter has had a public statement about the number of spam accounts, and that it seems like that might not be accurate. Tell me about the 10K and this representation of how many spam accounts there have been.
So Twitter, I'm not an expert on Twitter, but from what I've seen over many years, they have made a reference in their public filings to spam accounts. They reference the number 5%, and they indicate in there how difficult it is to really calculate that number. And they caution the public reading the document that these are estimates and they can't be relied on. But the number is important because if it's significantly more, then the key metric which drives Twitter, which is what they refer to as, I think, MDAU, which is monetizable daily users, is smaller than maybe what they've been representing. And I think that's where, I'm guessing that's where maybe Musk is going with this. But from a contractual legal perspective, this all goes down to, if the information which is provided to Musk turns out to prove Musk's theory, let's say, that the spam count is significantly more, then is that grounds for him to be able to terminate this contract, to be able to exit the contract, to be able to prove there's a material adverse effect? And that's where I think we'll see in the coming clauses where that turns out to be relevant, and the fact that the information was previously known and public, is that, once you know something or should have known something, is that something you can rely on as a breach of a representation? Yeah. I think we'll see that in some of the next clauses.
Yeah, and that brings us to an interesting shift in the argument that is rooted back in the contract. I would point out that a company called SparkToro has done an analysis, and the way they did it, which may not be agreed to by Twitter and Elon Musk, but the way they did it, they're estimating about 20% of the accounts on Twitter are spam accounts. But the question is, who cares, right? Even if that's true, who cares? Initially, Elon Musk and his lawyers, their argument was, okay, you guys didn't give us material information, and the document is saying, it's okay. Like, that didn't change anything. But they recently had a shift that is rooted in a definition that you wanted to highlight: company material adverse effect. This is back in the definitions. And it says any change, event, effect, or circumstance which has resulted in or would reasonably be expected to result in material adverse effect on the business, financial condition, etc. Talk to us about this definition and how Musk and his lawyers are now using this definition to try to get out of this deal.
Yeah, so I think, and I might be wrong, but if this deal ends up in the Delaware Chancery Court, then I think that the interpretation of this clause is going to be very significant. And I think that the argument, if you were looking to exit the agreement, would be that the spam count, let's assume it's 20% or higher, is an effect or a circumstance which either constitutes a material adverse effect, and we'll look at what that means, or is otherwise a breach of a different representation. And the reason why that is important is because contracts like this, and essentially any purchase agreement, will have what's called conditions to closing, meaning those conditions have to be fulfilled in order for the parties to be obligated to close the deal. In this case, in order for the buyer to be obligated to close the deal, there cannot be any material adverse effect. If there is a material adverse effect, then the buyer does not have to proceed with the deal. And so that's why this definition is so important. And so this provision is very typical. I would argue, and I think it's been argued in case law, including in the fairly recent Acorn case, that this clause is very much forward-looking. So when you read this clause, you look at the words in the, I think it's in the, where is it now? In the second sentence, any change, event, effect, or circumstances which would be reasonably expected to result in a material adverse effect. It really seems to be talking about something which is future looking and happened sort of going forward, rather than something that maybe happened in the past. So they have this initial introduction to the clause, and then they have a number of provisos. So they say a material adverse effect is something which is going to have a material adverse effect, a material effect on the conditions of the business. And then they go on to say, but doesn't include the following. And they list a whole number of exceptions. The purpose of these exceptions is to shift risk. So you could think of it very simply in the following way. In a material adverse effect clause, there is the business risk, meaning the risk that something might happen inherently to the business. You may lose a customer, or there may be faults in your product, demand may drop off, supply problems may happen. Those are inherent to the business. And then there are events which are out of your control. For example, it lists here COVID, changes in law, cyber attacks, general market changes. And those are risks which a seller typically can't mitigate, right? Those are things that happen. And so all of these exceptions seek to shift the risk back to the seller, whereas away from the seller, back to the buyer, because the seller can't be responsible for them. And so, in our particular case, what Musk would seek to argue would be that the increase in spam accounts, or the false number of spam accounts, is a material adverse effect because it affects the business as a whole. What I think the other side might argue is a couple of different things. First of all, if this was so important to you and this is something you should have known about, then you should have, you're a sophisticated person, you should have put this into one of the exceptions to this agreement. And furthermore, this clause refers to affecting the business when taken as a whole. And it's not clear to us that spam accounts really make a big difference. I mean, if you look at the recast numbers that Twitter did when it recast the difference of this MDAU I mentioned, the monetizable daily active users, was a difference of 214 million to 216 million. So it wasn't necessarily a massive difference, and it's difficult to see how it translates into the bottom line. So it's going to be very interesting to see kind of how this argument plays out around this clause.
Yeah, and their argument now, which is fascinating and sort of implausible, which is what makes it so interesting, but it's a colorable claim, as we say. The argument now is that they can't get financing. Originally, Musk was pulling money from three sources: from his own money, from debt against his interest in Tesla, and from debt with the assumption that Twitter's financial gains are going to pay back that debt in the future. Apparently now, post the stock market sort of dropping quite a bit, that second source of money is not as available. It's hard for him to go get debt on Tesla stock, and so now he's freaking out a little bit. But the argument that he's making on that third source of money is that he can't get the debt against Twitter's future revenue because there are just too many spam accounts. Nobody knows if that's true at this point. Nobody, obviously that would come out in court. But that's the argument that's happening right now, is that he can't financially make the deal happen because Twitter didn't reveal some information that was necessary to make the transaction work. I'm looking down at 7.2 in the conditions to the obligations, and it talks about some of this. These breach of representations in B. Did Twitter, in saying we have X number of spam accounts in their 10K, but actually they have Y number and they just didn't do the legwork to get the right number, did that undermine Musk's ability to even finish this transaction? What do you think about Section 7.2?
Right. So I think 7.2 is really a key section. When we look at Section 7.2, Section 7.2b1, where it says each of the representations and warranties of the company contained in this agreement, and it excludes a couple of representations, which typically refer to capitalization and other things, without giving effect to any materiality or company material adverse effect qualifications therein, shall be true and correct as of the closing date. But then it goes on. There's a line just before the word and the Roman 2, except for such failures to be true and correct as would not have a material adverse effect. So this seems to say that even if there would be a breach of a representation, if that breach or that lack of truth would not have a company material adverse effect, then maybe as I'm reading it, it wouldn't necessarily be a breach which would rise to the level of something which would stop this closing condition from going through. Now, to your question, there is a provision in the agreement in the representation section, and in a second I will find that, which relates to their SEC filings.
Yeah, and I would point out that they initially did say that the reason that this contract shouldn't hold was because there's 20% instead of 5%. But that argument just didn't work. I mean, it in the public eye, as they were putting it out into the world, everybody was saying, dude, did you read this contract? That's not enough. Now they're at this argument of it's making it impossible for us to get a loan, which is different, right? That's taking it to the next level, to your point about the adverse effect. But yeah, sorry, back to the representations.
Right. So absolutely. So 100%. And I think if you look in there's the representation section 4.6, which is the company SEC documents. You look at section 4.6a, where it says, since January 1st, 2022, the company has filed SEC documents, blah, blah, blah. As of their respective dates, etc., etc., the company SEC documents complied in all material respects with requirements of the Securities Act and the Exchange Act. So and maybe this is, this is all speculation and it's fun to do, but if he is able to prove that the erroneous statement, the suspected or alleged erroneous statement of accounts is so significant that it's something that and it's something that they knew about, is something that should have been something material that should have been disclosed in Twitter's SEC documents, then he may have a shot at trying to allege that there's been a breach of this particular provision. Again, this is, maybe what the person drafting this at the time was not thinking about. Obviously, this is a standard clause that you see in all of these agreements, but that may be a route that they're going down. And in and out of itself, if he is able to prove that, then Twitter may have a problem. And that sort of gamesmanship of, maybe causes to bring them to the table in a way to avoid something like this. But that might be, one area where you would try and take a crack at a breach of one of these representations.
Well, and before we get to the performance that's needed by each party, if this is successful, if either the contract does exist or does not, after scrutiny from the judge, where is this idea of the waiver of due diligence coming from? I've seen this in the media, to your point. I've seen there was no way for Elon Musk to know XYZ because he waived due diligence. He could not go find this out because he said, don't worry about it. I know what I need to know. I'm just going to buy this thing. Where is that coming from, this idea of the waiver of due diligence?
Well, I mean, I think it's, there's nowhere in here which, has in big capital letters, I have waived due diligence. And there's, I haven't found him saying that, but I think it's, people are intuiting that as a result of the back and forth between them and the speed at which he went from the position he was in to closing to signing this deal. Right? You can imagine it's such a significant deal. There are so many moving parts, yet they concluded it in lightning speed. But I think in section 5.11. If you look maybe several lines down, the sentence that begins, each of parent and acquisition sub has conducted to its satisfaction its own independent investigation, review, and analysis of the business results of operations, prospects, conditions, or assets of the company and its subsidiaries. So that's not so unusual. You do see that in many agreements. But then he goes on and on and on. And they go on to say, parent and acquisition sub hereby acknowledge that notwithstanding anything contained in this agreement to the contrary, neither the company nor any of its subsidiary nor any other person makes or has made or is making any express or implied representation or warranty with respect to the company or any of its subsidiaries or their respective business or operations in each case other than those expressly given solely by the company in Article 4. And it continues in a similar vein to say that the purchaser is not relying on anything which hasn't been expressly said here. So, in one sense, this is a fairly standard clause, but when you add this together with the context and the fact that there is no closing condition for him having the right to do due diligence, I think that's how they get to the waiver of due diligence. Because if he would have wanted due diligence to be a condition to closing, then it would have been a condition to closing. And I think that's what they're getting at between these different clauses.
So let's just say one way or another, I mean, clearly Elon Musk has buyer's remorse. Let's say one way or another, they're trying to find a way out of this contract and they do it. The question is what happens? What happens with this agreement that has been in the air for months now? Down in 8.3b, it talks about a termination fee, and that parent termination fee was defined up in the definitions section at $1 billion. So look at 8.3b and tell me, can he just do this? If they decide to get out of this, is he just paying $1 billion and moving on with his life?
Yeah, so I think it's interesting. The easy, I think the easy commentary in a way is to say, yeah, if he pulls out of this agreement, he has to pay $1 billion, and that sounds like a lot of money, but it's not a lot of money when you're on the hook for $44 billion. And so I think the answer to your question is yes, and maybe more, or yes, or if he does not have valid grounds for terminating the agreement and doesn't close or doesn't terminate the agreement, or wrongfully terminates the agreement, then one of two things can happen. Either, I believe, under this section 8.3b, Twitter could seek to receive payment of the termination fee of the $1 billion, or as maybe more of a risk, is that they will seek to enforce the agreement and enforce something which is called specific performance. And if we I may be jumping the gun a little bit, but if we kind of scroll down to section 9.9b, what this does is say, notwithstanding anything to the contrary, including the availability of the parent termination fee or other monetary damages, remedy, or award, it is hereby acknowledged and agreed that the company shall be entitled to specific performance or equitable remedy to enforce parent and acquisition subs obligation to cause the equity investor to fund the equity financing, etc., and to consummate the closing if and so for so long as, and it goes on. And what this means is that Twitter may have a choice, which is either to try and collect the $1 billion or to go to the court and ask the court to enforce this agreement to be consummated and for the whole consideration to be paid over. And I think that is if I'm on the side of the buyer and I wanted to get out of the contract, that would be my biggest concern. And that's why many times, and I'm sure it was deliberate here, this is not, it was deliberate and it would have been known by both sides. Very often in contracts like these, you would see a provision that would say that the termination fee or damages is the exclusive remedy, and that specific performance is not, and that would exclude specific performance. But because specific performance is specifically enumerated as a remedy, very specifically, um, that seems like something the parties thought might actually happen, or at least the seller did. And I think that's the big risk that Musk finds himself in the Delaware Chancery Court with a judge who is all about the freedom of contract. And we'll look at this very carefully. We'll see two very sophisticated parties, and may not be overly persuaded that questions the buyer could have asked before the deal was closed are now being asked. And I think that, I'm not a prophet, but I think that might be how this begins to play out.
Yeah, and stepping back to sort of the big picture, there is an interesting question about why Twitter is doing this. They knew at the time that Elon Musk is, we'll use mercurial as the nicest word for his temperament. They knew that he was shifty and knew that things might change, and that they trusted him for whatever reason to take their baby, to move on with this baby. The idea has been that probably they were just looking to maximize the share price. And so they picked a moment in time and said, we're at a pretty good share price now. Let's have everything based on now. To me, that says, getting to the purpose of contract, that says that at this moment in time, at some moment in time, there were some expectations and some assumptions. They were the spirit of the deal. And we all know in contracts that could be undermined over time. Maybe the only thing about the spirit of the deal that has changed is that Elon Musk has changed his mind. He's just not as interested in it. In reality, we're looking at all these other things to find some other thing that has changed. But clearly something has changed in his mind, and there's some buyer's remorse. When I'm drafting contracts, when I'm trying to put these things together and serve the purpose of the contract, are there better ways to try to protect the intentions of the party so that they stick? Is there some variable way to say, okay, we know that we're arbitrarily picking this moment in time. Let's have some more flexibility about what happens. Is this change in share price? Is this more like, this wasn't force majeure. This wasn't COVID, but you might argue that this was finally the stock market collapsed because all the money the government was putting in because of COVID stopped, right? And so now we are facing this inflationary pressure. So the point is, something has changed. Whatever the intentions of the parties were, they've now changed. How do you deal with that in contract in a way that doesn't just, undermine the purpose of the deal, but also undermines the future the future state that both of these parties saw after this transaction? That seems to have changed.
It's a great question from a practitioner's point of view. It's very rare to see the circumstances of a contract play out so publicly and so quickly after the contract has been signed. I think and actually, I don't think I have a good answer for you in this particular case because it's a very public, high stakes contract, and I look at it from the eyes of the board of Twitter and the lawyers of Twitter needed to make sure that there was a lot of certainty that this deal would go ahead. And so, the almost kind of the contrary of what you were saying, there are some times when you need to be pretty inflexible. And if somebody is going to come and put a big chip down on the table like that in a very public way, with all of the ramifications of it being a public company, then you can't allow for wiggle room. And why should you? Because essentially what's happening is everybody has an agenda. I'm not saying whether that's right or wrong, but it's just the fact that everybody has their own selfish agenda. And the role of, in this case, Twitter's lawyers was to give as much certainty as possible. And I think, if anything, it's the hubris sometimes of not doing due diligence, right? If that's important to you, or if it's important to your client, then sometimes you need to be unpopular, and you need to put in that extra caveat into the material adverse effect clause, or even identify it as something that is specifically important that if there's a material change in that metric, then that would be constituted in its own right a material adverse effect. So I think it's a question of discussing with your client what are the most important drivers of value in a particular transaction, then trying to determine whether any change in those drivers before the transaction is closed would cause you to want to eject the transaction and how much they would be, and then deciding whether they're covered or not. And it might be that you go through all of that discussion and you come to the conclusion, you know what, my client's going to roll the dice. But I think the important practitioner question is actually to have the conversation and to understand that. Now, we can't play the Monday morning quarterback here because, who knows whether that conversation happened and what the result of that conversation was. So I don't blame anybody here. It sounds, you can kind of just imagine the conference, the Zooms on this deal, and how quick they were and how stressful they were.
Yeah, and maybe the lesson here is no matter how ironclad your drafting is, client's gonna client. Sometimes these are just human beings and they just do things and you're trying to do your best. But to your point, there are a lot of people relying on where this contract goes. There are careers on the line. There are shareholders. There's just a lot on the line. And so maybe that inflexibility is actually important. So I appreciate that perspective. James, we are grateful. We're sure that the drama will continue. We know that a deal like this is going to provide future fun, but I appreciate you giving us the state of things for today. James, for people who want to learn more about your practice and get in touch with you to talk, there's always going to be drama, James. We're always going to want to talk to you about it. What's the best way to reach out to you?
The best way to reach out to me, Google my name on LinkedIn. I have the benefit of a very unusual name. There is only, I think, one in the world. So go on LinkedIn and you'll find me.
Great. We'll have a link to that, as well as a link to these documents that we've talked about. And if you want to be a guest on the Contract Teardown Show, all you have to do is email us. We are at community@lawinsider.com. We look forward to having you and to talking to you all next time. Thanks, James. Have a good day.
Thanks a lot. Bye.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.